The next item on the agenda is a little unusual, and I have to introduce it. Several years ago at the American Inn of Court, actually Harry Phillips Inn of Court, that met at Vanderbilt at that time, we did a program on this case. This is when we discovered, by the way, we're allowed to use the recordings that David Tune had made. But we also had a guest at that particular meeting who was on a panel discussion, who was a personal friend of mine and had told me a story that I'll have to say I found quite unusual, but he's a former newsman. He now works for the district attorney's office in town, so I considered him a reliable source. So I want you to listen now to what Ken Whitehouse has to say about a childhood memory of Bill Powell.
Bill Powell's first wife was named Helen Sudduth. Her mother lived across the street from me growing up. Her mother liked Bill Powell better than she liked her own daughter. Bill Powell divorced her daughter, and he always took care of her. I mowed Miss Sudduth's yard. She was also named Helen, by the way. And one of my first introductions to the law as a 7-8-year-old was hearing about this case from Miss Sudduth telling my mother different things about the case and what have you. The reason I remember Bill Powell vividly is he would show up across their driveway would run basically across from mine. He would show up in a DeLorean. And as an 8-year-old, DeLorean, this is before Back to the Future. It was a fascinating car. This is actually, what I'm about to tell you is the statement that really got me in a lifelong interest of this case. And the reason I'm here is because I told it to Ed a while ago, or several years ago, is I'm not really paying attention, and Bill drives into the driveway one day, and Miss Sudduth looks out the window over her shoulder and sees Bill drive up. And she's not really looking at my mother, and she's just speaking as an 80-something-year-old woman does, off in the distance, or man, please forgive, and says, "Bill's here. He's such a good boy. I know he killed that man, but he's such a good boy."
Now, I think that story is the last chapter in the book that Martha Smith Tate has written about this case, The Last Ride. And you may have noticed when you came in, there was a table there, and those books are available for you to purchase here today. And we have to confess that we have used the book liberally in filling in some of the gaps that we had in our story. Once again, divine providence comes together, and the book was published as we were working on the project. So things do tend to work out. Let's talk a little bit about jury selection and opening statement. I think the first thing you have to admit about jury selection is that it's more art than science. I've kept some records, and I think I have about 170 jury trials over 5 decades. And during the evolution of that process, I think I've learned a little bit about it, but I'll tell you what, I know very little. And any lawyer that tells you he's got that figured out, that's suspicious in my opinion, because it is the great art of trial work. One of the reasons I know that is that Aaron Wyckoff, one of my big friends in the DA's office 50 years ago, gave me a copy of a book called The Ninth Juror that was written by Gerard Chester. It's the story of a member of a jury, a murder case jury in the Bronx, New York, and about how wrong the lawyers were about all the choices they made. The Hispanics are going to do this, the black are going to do this. And as the juror, he knew what they were doing, and he said they got it all wrong. And I just have the kind of country belief that all the focus groups and the experts that try to tell you what a jury is going to do is a big waste of money. The other thing you might look at on that is the movie 12 Angry Men. Some of you have probably seen that. You know how that turned out. But nonetheless, art, just like science, does require discipline and practice. So in 1983, I was able to spend a few moments with Jack Norman Sr. at the TBA convention out here near the airport. I was president of the bar that year. And so I had a few minutes to just talk with him casually. And I actually asked him, because I'd already been practicing 10 years at that point, and I asked him what he did in jury selection. And I'll never forget his advice. He said, Ed, I just get rid of the bad ones and make friends with the rest of them. And you know what? That works. And that's the best advice you'll ever get. Now, the question is, who are the bad ones? You know, if you're in the country, and by that I mean a rural area like Centerville or Hohenwald, you might want to talk to the best lawyer in the county and find out who everybody is on your jury list, because it's not necessarily true that bias and prejudice is set aside when you enter the jury box. And in small towns, people know who's who, and the best lawyer in the town usually can tell you who you need to get rid of. In the big city, it's not quite as easy as that. But I will tell you this, I think Jack Norman Sr. had tremendous home field advantage in this trial. I'd like to have you hear now what he had to say about how he actually won this case.
After much reflection, that I won that case when I picked the jury. As I've told you before, I've spent much of my life studying jury selection, because it is with juries that all of my success has depended. I never made any money out of the appellate courts. If I couldn't win them right there before a jury, whether it was a criminal case or a civil case, I couldn't expect much to win them otherwise. I never had much professional interest in the appellate courts. Mine was always with the 12 men, or now 12 men and women who compose the jury. And I studied them. I spent a good part of my life. I tried to know when I got a jury list where every man, what part of the county he came from, what he did. If he'd ever served on a jury before, I had his name, because I kept a list of every juror in every term of court ever I had for future reference. And I could look back and tell whether if he'd been on a jury before, whether he'd been inclined toward conviction or acquittal, whether he had been a stooge of the district attorney, or whether he'd been an independent sort of juror. And through that, and that's the only way you can get it through long years of experience. And I had the advantage of course, Tom Schreiber never tried many cases in his life, and Hooker had never engaged in the criminal court like I had. Hooker had been principally all of his life in the civil courts, and he was only in the criminal courts of the criminal cases that Seth and I were in of some magnitude. And I think in fact, I know I had the advantage over John about a knowledge of picking juries, especially in the criminal court. And then I knew a lot of them. I knew the families, I knew the connections in the county, and I could always try to find some mutual thing that he and I, the prospective juror, and I knew about or had experienced, or our kinfolks had, establish some rapport with them, some connection. Not so much expecting them just to decide for me just because it was me, but to incline him to give me favorable consideration, and certainly not to take anybody that I knew by some past experience would be out to slit my throat. And you must understand, whenever you try a case, the people on your side think you're wonderful if you win, but the people who lose don't like you. And every time I tried a case, it was a 50-50. Usually 50% of the people involved liked me and 50% of them didn't. So in the future trial, all future trials, I had to look out for those who were on the losing side of cases that I had, or whom I might have offended by cross-examining in certain cases. So I had to more or less tiptoe through the tulips whenever I picked a jury.
Well, I think he was doing more than tiptoeing through the tulips. I think he had the records, he had the knowledge and the experience that even though there were great lawyers in this case, I think you would have to agree that Mr. Norman had the home field advantage. You know, even though we say get rid of the bad ones, how do you know who they are? Well, you've got to do some questioning, of course. And nowadays, particularly in federal courts, you're very limited on how you can frame those questions. It used to be that we would kind of make our opening statement in voir dire. You know, you select the jury and you tell them a little bit about the case, and then you tell it your way. And of course, the judges would frequently object to that. And it's more frequent now than ever. I tried a case in federal court in Alabama earlier this year and got almost completely shut down. I'll say that. Okay, so anyway, let's think about this. What do you need to do on jury selection? Let's assume that you have some of the advantages that Mr. Norman did. Well, you still have to, you know, as he said, make friends with them. One of the best lawyers I ever saw at that was Joe Binkley Sr., the father of our circuit judge, Joe Binkley Jr. And he was so charming and so witty in front of the jury that I really believe that some juries granted him the verdict just because they didn't want to disappoint Mr. Binkley. And you may have seen that if you've tried cases outside the metropolitan areas, you may have seen that with certain country lawyers who had a relationship with local people that an outside lawyer just really almost couldn't overcome. Another key point, of course, is to ask your questions of the jury in such a way that you let them know what the big issues in your case are going to be so that they're ready for them when the time comes. And you can tie jury selection with cross-examination of key witnesses and the jury charge itself. So be sure you look at the jury charge first and kind of go from there. I remember some of the testimony in the case. It was in the newspaper. And I guess we've mentioned this. We used the newspaper a lot. My mother, so I was in the Army when all this was happening, and so my mother saved the newspapers, and I read every word when I got home. I'd been drafted out of law school in 1968 as a result of all that stuff that Martisa was showing us. And I remember in one of those accounts that some reporter pointed out that Mrs. Chastain, by the way, they published the jurors' names and addresses in the paper. Times have changed, boys and girls. But Mrs. Chastain and possibly other jurors actually smiled at the defense table when they came in to announce their verdict. But it's also important in jury selection not to make mistakes. And one of my favorite mentors on that is Judge Higgins, because Judge Higgins used to describe not making mistakes as being careful. And if you tried a case in front of Judge Higgins over there in the federal building, and he said that you had been careful, what he meant was you tried a good case, because that was a key point for him to not make any mistakes. And let me point out one quick mistake that I think the state made in this case. And it was a mistake that we all made back in those days. We used to try the murder cases, first degree, of course, and death qualify the jury. But it was permitted because back then it was all jury sentencing and there was no bifurcation. And so if you were eligible for the death penalty, first degree murder, kidnapping, armed robbery, and maybe some others, then you could ask the jurors if they would impose the death penalty if there was a verdict of guilt. And what we did that for, which I think was clearly wrong, but we didn't know it, was to get a tough jury, because people that were willing to impose the death penalty tended to be harder-nosed people than those who couldn't. And there was a problem with that, because the death qualification stuff offended some of the jurors in the Powell case. But listen to what we had to say about the death qualifying. In most of our first-degree murder cases, we would death qualify the jury, meaning we would ask the jury if they could impose the death penalty, usually knowing that we were not going to request the death penalty. You can't do any of this today. But that would get you a pretty hard-nosed jury most of the time, because people who said they could not enforce the death penalty were excused for cause, because at that time, the law was that you could consider the death penalty.
And armed robbery was
Armed robbery and
capital-
rape and kidnapping were
yeah.
all capital offenses. Yeah. So don't make any mistakes, but it's always easy to say that, and kind of hard to follow your own instructions. I'm going to very quickly now say something about opening statement. You might think it's odd that we have a section on opening statement in a case where there was no opening statement. A lot of people don't understand that there's a difference between opening statement and opening argument. Even the Tennessean, which ran an article that we saw that said there were no opening arguments. At the beginning of the case, it's called a statement. Argument, per se, is excluded under the law because you haven't shown the jury any facts yet, and yet people often confuse it. Now, the reason I wanted to leave it in was that it's curious to me that in July of 1969, the exact month when this case was tried, the Tennessee legislature enacted a statute that gave you the right to make an opening statement in both a criminal and a civil case. And it's my belief, I can't quite prove this, that the trial lawyers, many of whom were in the legislature back in those days, had been shut down, particularly in rural areas, of making an opening statement by some of the judges that wanted to go faster than they did. And my partner, John Holland Sr., was a huge fan of opening statement. He thought that there were some cases that he actually won because he made such a compelling opening statement that the jury was on his side from the start, much like Mr. Norman was saying about his jury selection. But the thing about that is you have to be able to tell your story. You can't just repeat the phrase, you know, the proof will show, the proof will show. That's not a good way to do it. The way to do it is to tell the story without argument so that you won't be called down by the judge. But that's all I have to say about the opening statement. Since there were none, we'll just move on to the next thing. Now, we're going to get down to the nitty-gritty next because Mr. Cantrell, Judge Cantrell, is going to come back and tell us about the state's proof, defense proof, rebuttal proof, rebuttal, and in other words, the proof in the case. And a lot of the things that you've heard so far will now sort of begin to come together. Judge Cantrell.
Yeah, in the words of Gilbert and Sullivan in the Mikado, here's a howdy do, or here's the state of things. The indictment reported by the grand jury on March 29, 1969, charged Bill Powell with a first-degree murder in the slaying of Haynie Gourley. The trial began on July the 21st, 1969. The state's burden then was to prove beyond a reasonable doubt that Powell had in fact shot Haynie Gourley to death on May the 24th, 1968. They had to prove that by circumstantial evidence because there were two things missing from the state's arsenal: any eyewitness to the crime and a murder weapon that could tie Powell to the shooting. The state had plenty of proof about the motive. Powell had a great thing going as general manager of Capital Chevrolet, and he was a holder of 25% of the corporate stock. He was earning $83,000 a year, or nearly 4 times more than he had ever earned before. Some of you older lawyers, in 1968, your first job made about $450 a month, probably. Powell was making $83,000 a year. If Powell left the company, as he had agreed to do, he would be giving it all up. The stock buyback was for exactly what he paid for it through a loan at Third National Bank. On the other hand, and every time I say that, I remember the story about Harry Truman, who once said that he wished all of his advisors had only one hand. But on the other hand, if Haynie Gourley died, Powell would be the sole owner of the franchise. If he could purchase the rest of the stock of Capital Chevrolet from the Gourley family, he would be the sole owner of the business that Haynie Gourley had spent 35 years building into one of the most successful Chevrolet dealerships in the country, which is exactly what had happened by the time of the trial. Powell owned it all. The first four witnesses were Josephine and Billy Gourley and Sam Fleming of the Third National Bank, and the zone manager of the Chevrolet company. All of the facts that you've heard about the state of things were just uncontested. So there was no drama about the motive. What was troubling to the state was having to prove what happened with the circumstantial evidence. You'll hear later about the charge of the judge on circumstantial evidence at the time of this trial. All of the inconsistencies that you've heard about, how Powell's story changed from somebody jumping in the car and down at the Spence Lane when nobody saw it, nobody had seen any witnesses, any pedestrians in the area. On the fourth day of the trial, the state proved that the police had received a tip in September of 1968 about a possible suspect in the case, a black man about the size of the man described by Powell as the assailant. The witness showed a sketch of the suspect to Powell, who said he would like to see the man in a lineup wearing a hat. At the lineup, Powell positively identified the suspect as the gunman. Later, as the story began to develop, Powell denied that he was positive, changing his opinion to reasonably sure. It turned out that the suspect had an ironclad alibi. He had been at a Job Corps center in California for a month, on and around May the 24th of that year. We have some testimony about a police investigator who kind of engineered that whole sequence.
I had been investigating another murder. We're looking for a black man at a certain height and blah, blah. But I had been investigating another murder that he was in California. They found him in California and they told me about him. So I put on the streets that I had found a guy that done a shooting I was involved in. I didn't say that shooting, I said a shooting. Went to California. I did. Investigated this guy to make sure he was in a dental chair, get his teeth fixed when Haynie Gourley got killed. Got it laid it all out. Waited until a weekend when I knew that Cecil Branstetter was going to be out of town. Put it on the street. Talked to Bill Powell, got him to come up there and sit down. And he told me at one time the person that done the shooting had sort of facial issues. Told me all about it and almost cried. It's okay. I brought this guy in, put him in a lineup. Bill Powell said, it's him. He said, I won't never forget that face. And I thought to myself, I know that.
Well, it was not a good day for Powell when they proved that at the trial. And it was not until the fifth day of the trial, however, that the surprise witness showed up, who qualified almost as an eyewitness, and that was Walter Davis, as Frank has told you about. And he told about seeing these two white men in the car, hearing the shots, and then seeing them speed off. Which was really important, but the credibility of this witness was critical, obviously. And Cecil Branstetter and Jack Norman were veterans of this type of trench warfare. Mr. Branstetter took up the challenge. For 3 hours, he peppered the witness about his past, the time he'd spent in prison 22 years earlier for writing a bad check of approximately $20, his estimates of where he was and when he saw the car, and what and where some of the other large pieces of equipment that may have shielded him from being able to see anything that happened on Elm Hill Pike. The defense also questioned the police officers about when they discovered this witness. The officers had to admit that they had discovered him almost a year after the crime, and they did not know about him at the beginning of the trial. It was actually a policeman working for the defense who identified him. But with all that drama, the state closed its proof. On the next Monday, the defense's first witness was Bill Powell. He made a good witness. He recounted the way he was recruited for the job of general manager, his good relationship with Mr. Gourley, and his friendship with Billy. Said he still liked Billy. He admitted all of the controversy about the night that they returned from Memphis and his agreement that if they weren't satisfied with him, he should probably just leave. His story about the gunman amplified some of his previous testimony about how far down Elm Hill Pike they got before they were ambushed. He said this time they were almost to Massman Drive. His sketch at the beginning had shown the car going down Spence Lane and back, and that was as far as he said they did. But on cross-examination, Mr. Hooker asked him, how far did he drive after the assailant started shooting? He said, probably a quarter mile. Well, that seemed to me, when I first read it, that it takes a long time to drive on Elm Hill Pike, a quarter of a mile, but you had a man in the seat next to you who'd been shot dead, and it just seemed to be a little bit far-fetched. But the defense put on a witness to try to prove that Walter Davis was not at the location he said he was, and he couldn't have seen the Chevrolet car if he was. The proof sounded rather confusing to some of the spectators in the courtroom. Mr. Hooker pretty well blunted that testimony of the main witness, who wobbled about whether he knew Powell and whether his main purpose in testifying was to destroy the evidence of Walter Lee Davis. Next, the defense produced that surprise witness from Madison, Wisconsin, that Hal managed to find some way to discredit him overnight on a trip in a jet plane. He said that he had developed a soft X-ray procedure that could locate metal particles emitted in a gunshot. He testified in the jury's presence that the only shavings found on Powell's jacket were on the right sleeve from the shoulder to a little above the elbow. From that, he concluded that it would have been impossible for Powell to fire the shot that had wounded him in the left leg. At that point, it was about 4:30 in the afternoon, as Hal has said, and you've heard the story about how he came back the next morning with two witnesses. The remainder of the defense's proof consisted mainly of character witnesses. This list included the lieutenant governor of the state, 2 judges, 3 company presidents, the dean of the Vanderbilt School of Medicine, and Jim Reed III, a rival Chevrolet dealer in Nashville. They all talked about Powell's reputation for telling the truth. At that, the defense finally closed. At the beginning of the state's rebuttal, the court heard, in the absence of the jury, something that nobody had known about up to this point, that a .38 Smith & Wesson had been found on Elm Hill Pike. The court ruled that it would not take up that problem right at this stage of the trial. The Wisconsin sheriff and his deputy proved, well, about the only thing they could say, that was that the sheriff did not trust the Wisconsin crime lab. He sent all of his evidence to the FBI laboratory in Washington. But even better witnesses to cast doubt on the Wisconsin expert's testimony were special agents from the FBI laboratory in Washington. They completely discredited the testimony that the soft X-ray test could show that there were gunshot residue on the coat. The test could detect particles, but not the composition of the particles. And the FBI laboratory identified the gun that had been found on Elm Hill Pike as a .38 Smith & Wesson with pearl handle grips, serial number V46154. And that's when the real drama began. Bob Frensley, a former employee of Capital Chevrolet, testified that he had given the pistol to Bill Powell several months before Gourley was killed. He got it when he was in the National Guard, and he had replaced the original handles with the pearl handle now on the weapon. He stated that he had visited Powell in the hospital on the day of the murder and asked him about the pistol. Powell maybe seemed groggy at the time, but he told Powell that he had loaned it to a friend. Later, Powell said someone had stolen it from his car. The pistol had actually been found in August of 1968, almost a year before, as Frank has said, across the road from the Mount Zeno kindergarten, way back up the street near Capital Chevrolet. And the gun was stuck barrel down in the ground, which rusted the barrel. It couldn't be used to identify the bullets as that they had from the murder trial as the ones that were fired from that gun. Police had only learned about the gun the previous Sunday from an anonymous phone tip and retrieved it from the finder. Bob Frensley's cross-examination by Mr. Normal must have been masterful. In the final analysis, it appears that the jury didn't believe him at all. Powell took the stand again and testified that Bob Frensley had never given him a pistol. He stated that Bob Frensley had not asked him about the pistol when he was in the hospital, that Frensley had asked him later if he'd seen the pistol, and Powell said, "Bob, what pistol?" Powell went on to state, Frensley never asked him about the gun again. Now, the public anxiously anticipated a spectacular show from Hooker and Norman when they argued their respective cases. These two veterans had done it before. Their reputations for dramatic and powerful oratory were legend in the Tennessee legal services. Dewey Branstetter is going to tell us how all that played out.
The testimony was finished. The state had called their witnesses, as had the defense. The evidentiary portion of the trial was concluded, and the time had come for closing arguments, the spectacular conclusion to the trial that everyone had been waiting for. Hooker versus Norman, two lines of the bar going head-to-head to close out the most publicized trial in Nashville history. And then it would be in the jury's hands to determine the fate of Bill Powell. Whose closing would determine the final verdict? Would Big Bill Powell be found guilty on the strength of Hooker's closing argument? Or would he be found not guilty on the strength of Jack Norman's closing? But first, step back to the beginning of the case. As you've heard, the Gourley family wanted John J. Hooker Sr. to be a special prosecutor working with Tom Shriver to prosecute Bill Powell for the murder of Haynie Gourley. Why hire John Hooker? Well, Tom Shriver was very young. He was just 36 years old. He was also rather inexperienced. Shriver had assumed office, as you heard earlier, in September of 1966, less than 2 years before the Gourley murder. John Hooker was already 65 years old and very well known for his oratorical skills. Nashville lawyers knew that even after a bottle of his favorite scotch, John Hooker could argue with more passion and eloquence than any stone-cold sober member of the bar. He represented prominent citizens and businesses throughout Nashville, but he was known far beyond Tennessee. Hooker's reputation caught the attention of then U.S. Attorney General Bobby Kennedy, who engaged Hooker to assist Jim Neal in the prosecution of Jimmy Hoffa for jury tampering in the early 1960s. As a special prosecutor, Hooker also secured the conviction of Nashville lawyer Tommy Osborne, who, as you've heard earlier, had represented Hoffa and participated in Hoffa's jury tampering. Osborne was a promising young lawyer and a friend of the elder Hookers, a good friend of the elder Hookers, as well as Hooker's son, John J. Hooker Jr. Osborne was even in line to be the next president of the Nashville Bar Association before his unfortunate indictment for jury tampering. Hooker's impassioned arguments were just legendary. He was known to have made many a juror cry during his closings. He could go from a whisper that had the jury leaning forward with rapt attention to bellowing arguments that would hurt their ears. In his closing argument in the Hooker case, where he was prosecuting someone he knew, he stated to the jury in almost a whisper, "I've rolled and tossed at night ever since this has been going on, wondering if there wasn't some way I could be spared this." Then falling to his knees before the jury box, he proclaimed, "I hope you will not regard me as irreverent when I say that I have gotten down on my hands and knees and asked God that justice and only justice be done in this case." Osborne was convicted of jury tampering, many say on the strength of Hooker's closing arguments. And as an interesting aside, Jack Norman Sr. represented Osborne in this trial. After Cecil Branstetter was relieved as Hoffa's lawyer, Hoffa had approached Jack Norman and asked that he represent him. Norman didn't want to have anything to do with Hoffa, so Hoffa asked him, "Jack, who would you recommend that I hire?" And as Norman told the story, he was sitting in his office on 3rd Avenue with Hoffa there, looks out the window and sees Tommy Osborne come out of his office, which was directly across the street at 218 3rd Avenue North. So Osborne felt responsible for Osborne's involvement with Hoffa. Norman did not charge Osborne a fee for representing him. As you heard earlier, one of the reasons, if not the main reason, Jack Norman was brought on as counsel for Powell was to counter John Hooker at closing. The two had gone head-to-head many times before, most recently in the Osborne case. Norman was also known for his oratorical skills, but with a much different style than Hooker. Hooker was a man of bell mead and generally good-natured. He usually represented the upper crust of society. Norman was the grand old man of Printer's Alley, living in an apartment above his law office that fronted on Printer's Alley. He was crusty and caustic, preferring to represent the underdog. While Powell could hire whomever he wanted, it took permission from Judge Cornelius for the Gourley family to hire Hooker. So at the urging of the Gourley family, General Shriver requested that Judge Cornelius appoint John J. Hooker as special prosecutor. Concerned that Hooker's oratory might sway the jury to convict Powell, the defense objected, asking the court to enjoin Shriver from permitting any attorney retained by any private citizen from intermeddling or continuing to intermeddle in the prosecution of this case. But Judge Cornelius overruled the objection, and Hooker was on the case. Now back to the trial. Before closing arguments, the defense once again attempted to thwart the impact of the much-anticipated closing by John Hooker. Powell's attorneys insisted that Hooker shouldn't be allowed to argue at all. But if he were allowed to argue, then he must give the opening part of the summation. The defense argued that Shriver was the elected district attorney and that he was obligated to close the state's case. Judge Cornelius overruled the motion, and the jury would hear Hooker as the last lawyer arguing for Powell's conviction. Or so it seemed. Court resumed, and District Attorney Shriver then gave the opening summation for the state. He spoke for about an hour, mostly in a monotone voice. Shriver talked about motive and plotted through the evidence and the witness's testimony, but not with any particular passion. That was John Hooker's job on rebuttal. Shriver concluded the jury by thanking them and stating to them, "It is now the defense's turn to argue." Or was it? Before Jack Norman would argue for the defense, Judge Cornelius called for a 5-minute recess. After the recess, Judge Cornelius called the court to order, turned to the defense table and asked, "What says the defendant?" And perhaps the most shocking moment in a trial full of twists and turns and many other shocking moments, and with everyone anxiously awaiting Jack Norman's argument, Mr. Norman stands up, approaches the bench, and states in a thunderous voice, "Charge the jury, Your Honor." During that 5-minute recess, Powell had been presented a daring proposal. Branstetter told Powell that he and Norman did not think the prosecution's case was that strong. They explained that Shriver's technical and mechanical closing hadn't been persuasive. They told Powell that if John Hooker gives his closing, he'll wave Gourley's bloody shirt in front of the jury. His impassioned pleas might convince the jury to convict Powell despite the weak case that the prosecution had. Norman even pointed out that if Hooker can make jurors cry in a case when he represents the L&N Railroad, imagine what he would do with Haynie Gourley. But if Powell waived closing argument and Jack Norman did not argue, then neither would John Hooker. As Cecil described the scene to me, they were in a room off the main courtroom. Powell was sitting down. Norman and my dad were standing in front of him. And he said, Powell listened intently to the proposal. And after the proposal was made, they told Powell, "This is your decision," and asked if he wanted to discuss it with his family. Without hesitation, Powell stood up, said, "I don't need to talk to anyone," and instructed his counsel to waive closing argument.
But the two of you waived closing argument in a murder case. And many people thought that the reason for that was because of the extensive oratorical abilities of John Hooker Sr. in making a closing argument to a jury in a criminal case. Do you have any comment about that?
Oh, well, we talked at length, of course, but Powell made that decision, had to ultimately, to whether or not we would argue. Of course, that we knew that we could foreclose Hooker's argument, and he was a great lawyer, and he would have waved that bloody shirt all over that back and forth, up and down, walked back and forth. And I later learned from his wife that he had spent 10 hours before a mirror practicing what he was going to say. That's to his credit. I don't mean that, but it was amusing. She told me that, said he spent at least 10 hours in front of a mirror practicing his closing argument. Well, he didn't get to make it.
The dream match between Hooker and Norman, which some were saying would be as legendary as Bryan versus Darrow at the Scopes trial, would not come to pass. As fate would have it, the end of the Powell trial was very similar to the end of the Scopes trial. Most people don't know that after William Jennings Bryan gave the opening summation in the Scopes trial, Clarence Darrow then waived his closing argument, depriving Bryan of the right to make his final closing. Thank you, Ed Lanquist, for that information. The Gourley family was heartbroken. They had hired John Hooker to convict Bill Powell, and they believed that Hooker's closing argument would do just that, convict the man they believed killed the patriarch of their family. The man the supporters of the Gourley family claimed had stolen the Capital Chevrolet dealership from young Billy Gourley. Hooker's arguments may not have been heard at trial, but legend has it that all you had to do was have a few drinks with Mr. Hooker, and he would willingly reenact the best closing jury argument he never gave.
All right. Now, you may have noticed that the title page of our folder here says NBA Nashville Bar CLE. Now, that's supposed to stand for continuing legal education. We like to think of it as continuing legal entertainment. But being mindful that the commission is watching over our shoulder, and we've referred to various legal principles, we thought we ought to have somebody skilled in the law. And for that, we have hired none other than Circuit Court Judge Tom Brothers to come tell you about the jury charges, and particularly the charge as it relates to circumstantial evidence. Tom?
Good afternoon. I am so honored to be able to participate in this program. This trial and the excitement and impacts of it is the reason I decided to become a lawyer at a very early age. In the summer of 1969, I was a wide-eyed 18-year-old getting ready for college and discovering that there were incredible things happening in the world. People were walking on the moon. That had just happened at the beginning of this trial. Society was being transformed and the world was changing. One of the most incredible things that was happening was right here in Nashville, Tennessee, in the Bill Powell murder trial. I knew both families involved in this tragedy very well, and I assure you, it was a tragedy for both sets of families. And I tried to attend the trial every day. I'd sit on one side one day, one side the other. Talk about a dream team. There was Tom Shriver, John Hooker, and then some fellow named Hardin who was sitting with him at the table, I don't know, up against Cecil Branstetter and Jack Norman Sr. The entire Nashville community was riveted to this trial. Now, I need to point out two things. One, as Ed alluded to, on the cover of your little brochure there, that picture hangs in my chambers. That's Mr. Hooker and Mr. Norman during this trial, walking and talking. The civility and professionalism and common courtesy they exhibited for each other should be an example for all of us. They were ferocious advocates against each other, but they didn't let it get personal. And I also need to note, as a judge, how much I respect and appreciate the difficult task that was thrust upon Alan Cornelius. Certainly, this was the most high-profile case of his career, and it landed in his lap less than a year after he took office on September 1, 1968. I was in the courtroom on the day of closing argument, sitting next to Effie Hooker, and she was explaining to me what great oratory I was about to hear from her husband, John, and from Jack, and how impressive they are. And I didn't know anything about the law. I knew the families and knew people, but I was just eager to hear what this was. And then there was that dramatic moment when Jack Norman rose and roared, "Charge the jury!" It went up everybody's spine. It was amazing the way it affected everyone in that courtroom. Well, what exactly was it, though, that Mr. Norman wanted Judge Cornelius to tell the jury? Well, he wanted the judge, the only neutral in that whole proceeding, to explain to the jury the narrow and difficult path to a conviction based upon only circumstantial evidence. That would be a compelling argument for the defense in and of itself. So let's examine the jury charge on circumstantial evidence and why it mattered. Jury charges are important. Ed alluded to this earlier. When I was first practicing law, I had the privilege of starting my career under the tutelage of Jack Norman Sr. Worked in the Norman law offices. When I asked Mr. Norman how I should prepare for trial, he said, after your first interview, immediately turn to the jury instructions that will be likely used in that case. Those will establish the parameters and rules of the case, and you should define everything about your defense or as a plaintiff's case in a civil case, whatever. Your case will be defined by those instructions. And that is good advice to all of you that are still practicing. Now, there are two kinds of evidence: direct and circumstantial. Circumstantial evidence is proof of a fact or a group of facts that creates inferences that another fact exists. There are pieces of the puzzle that, when pieced together, will show what really happened. The prosecution in this case was built entirely on such inferences. In Tennessee, historically, circumstantial evidence, when used alone to convict someone of a crime, was always viewed with great caution. Accordingly, the jury instructions regarding it emphasized that the inferences had to be so strong and compelling that the only conclusion that could be reached would be the guilt of the defendant. The prosecution sought to establish motive by portraying the defendant as an angry business partner, being dumped from a business that he had built, angry enough to commit murder. The case was based entirely on circumstantial evidence, as I said, and among all of the circumstances were Bill Powell's own inconsistent statements, numerous inconsistent statements. The closest thing to an eyewitness only related to some black car with two white men in it, some man getting out and opening a trunk, closing it, and hearing what sounded like 4 shots. A pistol introduced by the state during rebuttal was linked to the shooting by where it was found and the location, by the caliber of the pistol, and the fact it supposedly had 5 empty shell casings in it. And there was some proof that there's some testimony that a .38 caliber Smith & Wesson pistol was allegedly given to Powell by Bob Frensley, a contention vehemently denied by Powell. Importantly, no witness saw Bill Powell shoot Haynie Gourley. So the charge given by Judge Cornelius was very different from the charge today. It was more restrictive and actually oriented more toward the defense. It required that the proof must exclude every other reasonable theory or hypothesis except that of guilt. Let's examine the evolution of the charge. In 1892, the Tennessee Supreme Court released Lancaster versus State. In that case, they pointed out that in order to warrant you in convicting the defendant in the case, the circumstances proven must not only be consistent with his guilt, but they must be inconsistent with his innocence, and such as to exclude every reasonable hypothesis but that of his guilt. For before you can infer his guilt from circumstantial evidence, the existence of circumstances tending to show his guilt must be incompatible and inconsistent with any other reasonable hypothesis than that of his guilt. In 1958, the Supreme Court again revisited this matter in the case of Marable versus State. And in Marable, they also talked about the jury charge and said the facts must establish every other reasonable theory or hypothesis except that of guilt, citing back to Lancaster. And in 1962, in Hardin versus State, the Supreme Court in Tennessee again pointed out that the facts must exclude every other reasonable theory or hypothesis except that of guilt. But in 2011, Tennessee Supreme Court in State versus Durantes abandoned this standard and adopted a federal standard which is less restrictive and is more oriented toward the prosecution. Rather than recognizing the Lancaster case and its 119 years of acceptance in Tennessee, the court stated it was departing from a 1971 opinion written by a special justice, Irby Lee Jenkins. And the court pointed out that the Crawford standard, that was the one authored by Special Justice Jenkins, purportedly required the state to prove facts and circumstances so strong and cogent as to exclude every other reasonable hypothesis save the guilt of the defendant, and that beyond a reasonable doubt. The court went on to point out that significantly, the United States Supreme Court has specifically rejected the notion that the prosecution is under an affirmative duty to rule out every hypothesis except that of guilt beyond reasonable doubt, citing the case Jackson versus Commonwealth. And they then went on to specifically adopt the standard enunciated by the United States Supreme Court in rejecting the remove every reasonable hypothesis. I'm beating my slides here too fast. So, curiously, the Tennessee Supreme Court cited a U.S. Supreme Court decision involving a bench trial. Jackson versus Commonwealth of Virginia was not a jury trial. It was a bench trial. Now, Jackson did cite the 1954 decision of Holland versus U.S., where the U.S. Supreme Court found that the government did not have the affirmative duty to remove every other hypothesis than guilt in a tax evasion case in which the prosecution relied on the net worth method, where they proved that your net worth's so high that the only way you could have accumulated is by tax evasion. Now, while many commentators have noted that the Holland decision should be limited to those type of cases and those specifics, it has been adopted by federal courts throughout the land as well as our Tennessee Supreme Court. And I can't let this go without noting, as a civil circuit judge, the civil pattern jury instruction today is still stronger than the criminal jury instruction. If you base your decision upon circumstantial evidence, you must be convinced that the conclusion you reach is more probable than any other explanation. So let's explore the charge given in the Powell case and with the current pattern instruction. Now, in Powell, Judge Cornelius charged, in proper cases, it is as much their duty to consider circumstantial evidence as positive and direct evidence, but before a jury will be justified in finding a defendant guilty upon circumstantial evidence, they must be satisfied from the evidence beyond reasonable doubt of the guilt of the defendant, and that such circumstantial evidence is not only inconsistent with his innocence, but that such evidence excludes every reasonable hypothesis except the hypothesis of guilt. Very strong charge. If given today or any time after 2011, the TPI criminal 4203, I'll put that up. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. It's your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the circumstances, all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. So, if that charge had been given, would it have made a difference? Think about it. Thank you.
All right, we're going to ask our panel members to come up. Mr. Harden, if he's not somewhere signing up with a movie contract. Ms. Tate and Mr. Koshy, if you would come up and take your seats, we will proceed. And I'm going to, since I am a lawyer, I'm going to make an appeal to Mr. Landquist. Since we started 10 minutes late, do we have to have a hard stop at 4:15? Why is that? Raise your hand if you'd like to go a little farther than 4:15 with the panel. Yeah, they're watching. Okay. Well, maybe we can go to 4:20 or something, but anyway. All right, I apologize that we have run over, but I think our presenters have really done an outstanding job, and I know that you probably agree with that. And I want to get right to it because we do have limited time. Ms. Tate, we really appreciate you and the job that you've done with that book. I know Sonny's read it because he's got 47 little pink notes on the side of his book there where he's marked pages. But could you give us, are your mics working, by the way?
Is it working?
Good.
Yeah.
Could you give us just 2 or 3 minutes on why you wrote the book?
Yes. I was one of the few people, handful of people in this room who was at the trial. I was also at Mr. Gourley's funeral. And his son, Billy Gourley, whom I think is here still. Yep, hey, Billy. Billy and I hung out. That's the word I guess that we would use. That year after we graduated in 1967 from Vanderbilt. And so I came up for the funeral, and then the next year I came up for the trial. And I missed the voir dire, but I was here for the testimony after I watched the moon landing and came to Nashville. And I sat through that trial, and I was one of the ones going, oh, you're kidding. I mean, it would be so dramatic. We'd get this witness and we thought, oh, this is great. And then all of a sudden, Cecil Branstetter had him on the floor, just had torn everything apart. So at the end of the trial, I waited with the family. It took 4 hours. We were hanging around Thomas Shriver's DA office was right next to the courtroom. And all of a sudden they said, the jury has made a decision. So we all filed back in, and I saw the first foreman come out, or the first juror, that door. We were watching. It took forever, it seemed like. And then Mrs. Chastain, with this big beige pocketbook in front of her, looked over at Bill Powell, and just this big grin crossed her face. And we were just, I won't say what the curse word that Hal said, but I was thinking of the same thing. I couldn't believe it. I had heard and believed, and I just couldn't believe it. And then for 50 years, I was haunted by it. I told the story to anybody who would listen. My poor children were in grammar school, 2 girls, and they had to hear every detail. So it was 2018, and it was January, and I thought, nobody's ever going to dig in and see if they can connect the dots of this case. And I think I knew what I thought, but I wanted evidence. And so I first of all, I made him an email to Billy Gourley and waited 3 months before I had the courage to send it, to ask him if he would help me. And to my great surprise, and I was so very happy that he said he would. And he introduced me to Hal Hardin and to John Lentz. My friend Jane, my sorority sister at Vanderbilt, found Sherman Nickens and Larry Britton. And so I was able to do interviews. Billy put me on to his friend Jimbo Cook, who's his dad's best friend's son. And Jimbo was there every day. He knew the trial by heart. So he unfortunately has died since, but I just milked him for every thought he ever had about the trial. So then I told Billy it'd take a year. 4.5 years later, I finally got the book out. And Hal, like 3 years in, he would call and say, oh, how's the book coming? Because he was heavily invested by now with telling me everything he knew about it. And I said, well, I'm on the Frensley case. He said, well, you were on that 2 months ago. So I literally read every single article. I read every word of the transcript. In fact, I would just go for months and weeks, and I don't know how, and I would be only like a few witnesses forward. So then I finally got the book all together, and I had a 780-page book. And my daughter works for Simon & Schuster. She is the director of publicity in New York. And she got an editor there to read what I had written. And I was just devastated when he came back and said, this is reportage. And that I had my research overwhelmed him. Well, I was just crushed. But then I sat down, and my daughter said, he said, I don't get a sense of the characters. And I thought, these were amazing characters. So my daughter said, think about your feelings, get more from Billy. And that was very painful for him, you can imagine. But I finally got it all together, and lo and behold, I was able to connect the dots. I could see there were pieces of evidence like Mr. Gourley's broken cufflink. I missed that, or I would have told that to my children over 30 or 40, 50 years. But they're not that old yet, but anyway.
Martha, let me interrupt you.
That's too long.
Because we are short on time.
Okay,
I
sorry.
would love to hear more of it. But
So the book is out there, and it tells the entire story.
Okay.
Thank you. I'm sorry.
I am really sorry I have to do that.
That's
But
all right.
we've got Sonny Koshy here, who's a former assistant United States attorney who's tried some of the biggest cases in federal court here over the last 20 or 30 years. And I wanted him to be with us because we all recognize, particularly people who are in the business, that there were some forensic evidence issues in this case from the very beginning. And so we kind of tasked him with the job of giving us an overview of mistakes that were made and how it might be different today. Sonny, can you do that in a few minutes for us?
I will try, Mr. Yarborough. First of all, thanks for inviting me to participate on the late edition. I'm really honored to be here with this respected group of Nashville lawyers. Obviously, they've spent a lot of time reading the transcripts, going through the audio, mistake. I spent years going through that. My source material was her book. And I did tab almost every page, just like I did in college. But I think what she said about giving a flavor for the case is really important. What I'd really suggest to a lot of you, I know you're all here for CLE, but if you're here and you've got a firm or you want to practice something, go get the book. It's a pretty easy read, easy to get through. You got the background now, and do sort of an internal development class. How would you handle voir dire, opening, closing, things like that? And I think it is would be a good exercise for you to do. So I said my source material was actually just the book, and I don't know if Jody's got my little PowerPoint. As you can see, I tabbed every page because I was trying to read it, and I was fascinated by this picture actually right here. The picture right there on the screen that's and there is the author and Billy Gourley, right?
Billy,
I was just like, oh my
Billy's
God.
still here? Billy?
Yep, right back
You still
there.
here?
Yeah.
He's with us today, by the way. Give Billy a hand, will you? Thank you. We really appreciate you being here. I'm sorry, go ahead.
So then I found this other picture, and that there is Mr. Hal Hart, right? So I was fascinated by that. And of course, since I had to take it as source material, obviously the cover of the book says it's a true story, and Miss Tate has told you why she's gone through everything. Ms. Harden, you sat through the trial. You think the book is true, right?
I do.
So what do you say about this, Mr. Harden? This is what Ms. Tate writes about Mr. Harden right here. Strikingly handsome, Harden was tall, with thick black hair and blue eyes. His good looks would soon become a topic of conversation among many young women who attended the trial. Page 199.
Well, those are days of yore.
Well, it goes on, though. So, let's see what else Ms. Tate said.
Thanks, Sonny.
Describing Mr. Harden, the exceedingly handsome assistant district attorney had continued to capture the attention of many young women who had seen him on TV or his photograph in the newspaper. So, a little expensive, Mr. Harden's expense, and of course he didn't know I was going to do that.
You cross-examined me very well and discredited me, so
I want to thank Sonny for his riveting analysis of the forensic evidence in the case. You know, since the CLE Commission is probably going to revoke our license.
Oh, wait. Here's my notes on the forensic part if anybody wants to hear it.
Yeah. It'll be in the same thing with Mr. Hooker's final argument, right?
I wave.
Okay. You've seen a lot of Hal already, but Hal, I'm going to give you an opportunity for rebuttal to what you just heard.
well, if you exercise and eat well, after 50 years, you can still look the same as you were back when you were 25 or whatever.
Pretty good. Pretty good. All right. Well, again, we apologize for the fact we are a little bit past 4:15, and I always do exactly what Ed Lankquist tells me to do. That's a record in I believe, the Blanton presentation. But before we quit, you just have to see this.
We got on the elevator. Mr. Norman was a friend of mine, but in a courtroom, ain't nobody your friend. Okay? So he said, it was going down. He looked at me, put his hand on my shoulder. I'll never forget it. He said, son, don't take this personal. This is not personal. The jury, his peers have spoken. And that's what we live by.
That's what we live by. Be sure to complete your blue form before you leave so you'll get CLE credit. And one more time, let's thank all these folks for what they've done.